And the pseudonym, what is the correct spelling?
Hailey.
And defense, you have no objections to those changes or the waivers?
I have no objections to those changes, and we waive the 10-day requirement.
And Your Honor, the word pseudonym is actually misspelled.
Okay. All right. Mr. Cruz, did you review the court admonishments with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. In count 3, you're charged with aggravated sexual assault of a child. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow that plea. If for any reason the court does not follow that plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? All right, we can go off the record for a moment.
Yes.
All right, did you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court, just 1 second, I'm sorry. Is pretrial services going to be able to read this?
I can try to type it.
I can type it.
All right. We're full service here. Thank you. All right, we're back on the record. All right, and did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea, you can be deported, denied naturalization, or the right to re-entry into the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 3. They're asking that your punishment be assessed at 25 years in the prison. There's a $1,500 fine. There are no applications. There's to be Chapter 62 compliance, and there's to be no contact with the complainants. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Yes.
No pretrial motions of that sort. No.
Then to count 3, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. The state would enter into evidence State's Exhibit 1 and all attachments.
No objection.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
All right, anything you wish to say on behalf of your client?
Yes.
Yes.
And so the defendant, my client does understand the ramifications of the charges involved. It was very difficult in terms of assessing what was at stake here. We have entered a plea to avoid the inherent risks of trial. The client, we are just asking that the state follow this, I'm sorry, that the court honors this agreement. This has been the result of numerous meetings with the state, going over the evidence, and the state has conferred with the mother of the child, and this is a conclusion that everyone is in agreement with.
That is correct, John. We asked for families that are in agreement with this.
Anything you want to say?
Just want to say that I'm sorry for everything.
But why would you do it?
Like in a way that
I'm sorry, what?
no, I would say like I'm sorry like for the
Sorry for what?
like when with the pain that I for her and everybody the not being a better husband to her, to
Well, I mean, according to the stipulations, you're the boyfriend. You're not a husband.
or boyfriend, yeah.
So how long did you know them before you moved into the home?
Like about a couple of months.
So you knew the mother for 2 months before you were moved into the home?
Somewhere around about 2 months.
Right. And how long after you moved in the home that you were allowed to spend overnights with just you and the complainant?
How long? Like
Yes. So you move into the home within 2 months.
because I would work at night. I'll come home. I work night shifts and 11 o'clock, 12 o'clock.
Well, they're saying this happened overnight.
yeah.
If I may interject, just regarding the facts of the case, since we're discussing this. My client had been on parole at the time these allegations were made. There was a parole hearing at which the mother of the child had testified. And during that hearing, she had stated that
Oh, okay, but I want to hear this.
she had.
I understand it's hearsay, but I want to hear. Yes.
And so this is what I had pointed out to the state when we were coming to this conclusion, this proposed amount. The mother was relying on him routinely throughout the course of their relationship to watch the children because she worked nights. She works as a housekeeper at the Metropolitan Methodist, the hospital on McCullough. And so that was an aspect here where she had asked him to watch the kids
So when did
that
that
night.
start? When did it start that you were allowed to watch children as somebody's boyfriend that has only been moved into the house for 2 months?
Like for me to watch her, like that was my girlfriend. We've been living like we got the house together. I'm the one that got the house, and we all
How did you meet her?
through Facebook.
All right, so you meet through Facebook, and when you meet through Facebook, does she already have children?
She already had children. She told me about her life story, how
Well, no. I just want you to listen to my questions and answer my questions. So you meet her through Facebook.
yes, ma'am.
She tells you she has children.
She didn't tell me at the beginning,
Okay.
not till afterwards that we started talking.
All right. And so
Started.
when you met her through Facebook,
Yeah.
did you already have prison history, or did the prison come after you met her?
No, I already had prison
And so what did you go to prison for?
for burglary.
All right. So
Never had no.
did you tell her you'd been to prison for burglary?
Yeah, because
So-
her ex said.
So you tell her, you meet her on Facebook. She has underage children, and you tell her that you've been to prison for burglary.
Yeah, I told her.
And then she says, great, you guys move in together. Okay,
Your Honor, may the
Yes,
state
ma'am.
ask the defendant some questions?
sure. I mean, he gave it the right to remain silent.
Mr. Cruz, isn't it true that you knew the child's mother for 9.5 months before you guys moved in together? Does
Yeah.
that sound more correct?
Yeah, I know. pretty much, something like, yeah.
And isn't it true that she had her father living in that home as well?
Yes,
And isn't it also true that you guys met through friends and not on Facebook? Would that be more correct?
then like Facebook, cause she knew my sister and all
So you guys knew
That's
each
a
other
yeah.
from people, not something that you met online.
that, yeah, so.
No further questions.
All right, anything else?
If I can briefly
Yes.
ask him, and was it your understanding that there were past allegations made against another family member in the house by the same child regarding sex abuse?
That changed relevance.
Overruled.
Yeah, her ex-boyfriend.
All right.
Oh, her son,
The son, would that be
yeah,
that
Jay,
his brother?
they had brothers, she had said that her son had did something to her own son.
And then what was the outcome of that
She didn't
allegation?
do nothing about it, I always told her, you son, she didn't want to.
And what is your understanding of her relationship with a man in a case where she was a complaining witness for continuous violence against the family?
And that was her ex, her baby daddy, she told me that they had got an argument and she hit him in the car and she ran over, he hit a bump and he was trying to put the car in gear and
What is your understanding of their relationship now?
they're gonna get back together. She could put him in prison for 4 years for domestic violence.
How do
He
you know
gets
that he
out.
was going to, how do you know that
She
they were
told
going to
me.
get back together?
She was talking to him. He will call her on
Okay.
three-way from people from prison. I was for a lot of arguing and I tell her, why you talking to me? Like, I'll just leave. I'll leave the house. She was always arguing with me.
Okay.
I just leave. I didn't want to get in trouble.
No further questions.
Okay, thank you.
Redirect, or I guess cross.
Sure.
How, you don't know for sure that she's with the person who abused her, isn't that true?
I mean, she was talking to him through the phone. Like
Would
when
it
I,
surprise you to know that she has a restraining order against him?
yeah, but she would still get letters for her friends. He would send letters to her friends.
Objection to inaccurate statement, a restraining order, would that be a protective order? I mean, that's.
All
to me,
right, if
that's
you could
important.
clarify your question.
Yeah, a protective order, Your Honor. Are you aware that there's a court order prohibiting him from talking to her?
Yeah, but and that's why I would tell her why she talking to him and he was still come through
No further questions.
and I didn't, that was one of the main habits.
All right. Is there anything else?
Nothing further.
All right, as previously stated, the court is going to find you guilty of count 3. The court will sentence you to 25 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrently. Chapter 62 registration. There's to be no contact with complainants. There's to be no residing with minors. And there's to be no unsupervised contact with minors. Anything else with regards to sentencing?
Okay, Your Honor.
Nothing further.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, Your Honor.
All right, we can go off the record. So here's the thing. The fact that some people are not paying attention to their children doesn't excuse your behavior. I have no idea why people will hang their star to somebody who's been to prison, which I believe in rehabilitation. But when you have children, you can't believe in rehabilitation because you have to protect your children. You can't be leaving your children alone with some guy overnight whether you're in love with them or not, and they've been to prison before.
Yeah.
And so I'm putting no residing with children because ultimately, when you're released from prison, somebody's going to see that you're a registered sex offender.
Mhm.
You may or may not tell them, I didn't do it. They're going to believe it. They're going to allow you around their children because for some people, you're a great catch and they don't pay attention to their children. They don't recognize that, hey, this child is 100% dependent on me for their protection. I can't leave an adult male in the home because sometimes this is what happens. But that doesn't excuse your behavior at all. Do you understand?
Yes, sure.
And you are not allowed to reside in any household that has children in there when you're released from prison. So if you meet somebody on Facebook, if you reconnect with somebody and they have a child residing with them, you can't live there. You can't spend the night. You can't be over there. Do you understand?
Yes, Your Honor.
All right, thank you.
And
You're
I do have a comment next to it.
Okay, sure.
You're back.
9-1, State versus Eduardo Escalera. So, Mr. Escalera, have you had a chance to think about what you would like to do?
Yes, ma'am. It's a SafeP program, and it's with a 3 to 6 month aftercare program. Is that correct?
Yes.
Yes.
All right. So,
Tends to be extended as well.
yes. So, Mr. Escalera, but you're going to be extended, but it's going to end up being a guilty verdict. So, I'm going to find you guilty.
I have a question. Okay, the 2 years, gonna be extended 2 years. Is it gonna be running while I'm in St. Pete? Like, let's say if I get out in a year, I just have 1 more year left, or does it,
I don't understand your question.
I think that your question is, you'll be on probation
okay,
or you're in safety.
okay,
Okay, that probation, as we talked, is going to continue to run until the end. And part of that will be at safety.
okay,
So when you get done with safety, you still have probation to go.
okay,
You got that?
yes,
Okay.
All right. So, do you understand?
yes.
All right, so this is what the court is going to do, and I think this is really in your best interest as far as becoming clean and sober, because I think everybody can agree you have a drug problem. And if that problem is not solved, then we're going to be right back here. And I'm taking in consideration that the fact that you want help and all of the allegations appear to be drug related. So the court is going to find you guilty. Just 1 moment. Does anybody want to speak to an underlying? Because I'm finding him guilty, but
Right.
I'm going to grant him, I'm going to place him on regular probation
We talked about the term, Judge. I guess we'd ask for 2 years.
for the underlying.
Oh,
Well, I mean,
oh, I see what you mean.
yes,
Um,
Do I still have the protective order, Your Honor?
yes, and there will still be a no contact order.
yeah, I'd ask for the minimum 2 years, Judge, an underlying sentence. I think you're right. The issue here is the drug problem. If we get that fixed, I think the rest of it would be all right.
All right, State, what are you requesting as an underlying sentence?
Still that's for 4 years, Your Honor.
Okay. All right, the court is going to find you guilty, sentence you to 4 years in the prison, suspended and probated. How long are you all asking for a term?
We'll follow probation's recommendation
Yes.
or
For the length.
for the length of 2 years, yes.
We'd ask for 2 years probation.
2 years probation, 4 years prison probation for 2 years.
All right, so this is what the court is thinking. There's a wait time for SafeP. And then that's 9 months. Then you have the aftercare for about 3 months.
It's my experience, it's been about 3 months.
So the court is going to sentence you to 4 years in the prison. The court is going to suspend and probate it for 4 years. Just 1 moment.
So I'm not going to safety then?
Yeah, you're going to be going to SafeP. You're going to remain in custody until SafeP accepts you.
Okay,
There is going to be a $1,500 fine. That will be probated. There's to be regular reporting by Zoom or in person. Regular random UAs. There's to be proof of employment within 45 days of release. no employment as a home health care provider or with minors. There's to be no contact with, I think this is Vanessa Pena.
Yes.
And she's also Vanessa Vasquez, is that correct?
I don't know who Vanessa Vasquez is.
They say that's a girlfriend.
No, it's Yvette Vasquez, used to be my girlfriend.
All right. Probation, there's to be no contact with Vanessa Pena or Vanessa Vasquez. There's to be,
There's no Vanessa Vasquez. I don't know.
okay, well, then you won't know one, right? Okay. There's gonna be 200 hours of community service restitution. Again, you're gonna complete this parenting class. Once the parenting classes are completed, 100 hours of community service restitution will deem satisfied. And the court is going to order 90 sober meetings in 90 days. For each completed sober meeting, that would count for 1 hour community service restitution. There's going to be field visits 1 time per month for 6 months. There's to be no residing with minors until further notice. And no unsupervised contact with minors until further notice. Probation, is there anything else?
Honor, I believe that he was ordered to complete the BIB program. Did we?
Okay, you're correct. So, and there's to be the BIPP course, and there's to be he's to remain in custody until transferred to safety.
Is there also gonna be an affirmative finding?
Yes, thank you.
Oh, wait, no.
No, there isn't, because this is, yes,
You don't have a question.
yes.
That minor thing, why is that? Like, I can't see my children?
No, you can see them, but as long as they're supervised, let me explain to you the reason why I do that. And I can explain that to you best by asking you a question.
Mhm.
All right, it's obvious you have a drug problem, right?
Yes, ma'am.
All right. So let's assume you have children, which you do, right?
Mhm.
And you need a babysitter, right? And so you put an ad somewhere and you say, I need a babysitter. And I see your ad and I apply for it. And you say, Stephanie, I need to be very careful because I really love my children and I'm looking out what's best for them. And you say, you can come by, I'm going to be here,
Oh, okay.
but I'm going to supervise, right? So you supervise me with your children. Children love me. I'm the Black Mary Poppins. They're like, she's so great. Please hire her dad. And you say, you know what? I'm going to hire her. As I'm leaving your house, I have an attack of conscience and I tell you, hey, I'm thankful that you want to hire me for this job, but there's something you need to know about me. I'm supposed to do UAs. I haven't been doing them. I have a drug problem. I don't have it under control, but please trust me with your children. Would you do that?
No.
And see, that's where you are right now. It's not where you're going to end up if you follow through on everything. So for the time being, if you're going to have contact with your children, it needs to be supervised.
Can my girlfriend count as like my?
You'll need to talk to probation. They will say who should be supervising. And your girlfriend, is she the mother of your children?
No.
Then that's not a good idea. And let me explain to you why that's not a good idea.
But I have a protective order against the mother of my children.
No, I understand, but let me just tell you why that's not a good idea. My experience in doing civil cases, because I've done civil cases too, where there's a blow up when somebody wants their girlfriend to supervise a pickup of their children or supervise their children. Usually the mother of those children don't appreciate that. Same way, if the mother of your children said, you know what, let me let my boyfriend supervise. You would be like, I don't want your boyfriend supervising my children. I don't know him that well, right? So that's probably not a good thing. So maybe your mother, their grandmother, or somebody else, or grandfather, you understand?
Well, on her side? Because
Whomever.
on my side, I don't know.
Probation will figure that out.
Okay.
Okay.
All right. Probation, is there anything else?
No, ma'am.
Is there anything else you need from the court to be successful?
No,
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
yes,
Are you waiving your right to appeal?
yes,
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes.
And I'm sorry, counsel, let me see. State and defense, I'm sorry, counsel. I'm proceeding with the same conditions he had when he was on deferred adjudication. The only addition is the safety. So I'm going to do GPS partial, waive fees, so you won't have to pay for it, and it's for employment. I've discovered that when people come directly from rehab and they have all this freedom, usually they fall off track. So once you're released from safety, once you show me that you're following through on everything, I'll probably end up removing GPS for you. But it'll be partial, so you'll be allowed to work and go to your treatment.
And I can still be in the riddle,
Hmm?
right? I can still be in the riddle.
That's what I was gonna
That's what I
mention.
need.
Yes.
His case was transferred for supervision to
All
Webb
right.
County.
All right, so it can be transferred to Webb County upon completion of safety. All right, so transfer to Webb County. All right, here's your trial court certification. This is your chance.
Yes,
You
ma'am.
understand? And if you have no intention of completing this, just tell me now. Don't be involved in your children's life, because each time you come in and out of their life, it sort of hurts them. You
I'm
understand?
gonna complete it.
All right, so do well, do it, all right? All right, good luck to you.
Thank you, ma'am.
Thank you, counsel.
Maybe excuse, Your Honor?
Yes, and probation will go over conditions with you. If there's something you don't understand, let them know.
Yes, ma'am.
All right, hi. So
Hi,
on
Judge.
this case, do you have all of the discovery?
Judge, I got handed a hard drive last week that had 431 PDF files, 98 videos, and 94 images.
Mhm.
That was the requested discovery that had asked for back on July the 8th.
Yes.
Okay, so I have not yet had a chance to review all those videos.
And I appreciate the fact that you said, I will turn over a hard drive later in the day, back in July, and you did it. Sometimes people will say, I have the hard drive now, so I appreciate that. So how much time are you asking for to review that?
Judge, 30 days if the court would allow it.
All right, Ms. Ferguson, I need a 30-day reset.
And Your Honor, also, I've already filed motions on this case.
All right, just one second. Excuse me, sir. Here's the thing. Do you want your attorney to go without having reviewed anything? What he has to review is a lot for him to review. If you want your attorney to go to court blind and be surprised by whatever the state presents, we can do that. But you're not his only client. So the fact that he has all of that to review, he needs to review it to be effective for you. You may continue.
Judge, I filed 17 motions this week on this case. One is a motion to suppress.
Mhm.
The other is a motion to reduce bond. And at the court's schedule, I'd like to schedule that as early as possible.
All right, so state,
Yes, Judge.
with regards to the motion for the bond reduction, have you had a chance to review that, and would you be ready to proceed on that?
Not seen that, but if I look at it, Judge, I can be prepared for it.
All right, so we may be able to take up the motion for the bond reduction today. The motion to suppress, I know the state is not going to be ready for that, because I'm assuming there will be witnesses needed.
Oh,
unless-
absolutely, Judge. The judge will need, I'm sorry, the state's going to need at least a week, I think, to get ready for the
All right,
motion to suppress.
because I'm assuming it's not just a search warrant where I can read it and say yay or nay. So we're going to come back on September 29th. Is that good for you?
That's good, Judge.
All right. And then state on September 29th, if you haven't done so, you'll need to be able to tender offer on that day. And an acknowledgement of discovery will be need to sign on that day. All right, so if y'all have a seat and if you'll confer with them on the bond, the court will hear the bond matter.
Thank you,
Thank you, Your Honor.
You're welcome. State versus Juan Alberto Martinez. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Robert Featherston representing Mr. Martinez.
And you are Mr. Martinez? All right, your attorney has filed a motion for a bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
All right. So according to this, your client is charged with manufacturing, delivery, controlled substance penalty group 1. Let me see. Is it over 400 grams?
That is correct, Your Honor.
Over 400 grams. The bond is currently set at $25,000. According to your motion, and you're asking for the bond to be reduced?
That's correct, Your Honor.
All right. Do you have any witnesses?
No witnesses other than Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Juan Alberto Martinez.
All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, you have a great concern about a family member. Who is that?
My mother was just diagnosed with cancer a week ago. And Mr. President has been doing a lot for me, but my case has been turned over from DA to DA to DA. I'm innocent of this charge, but I'm pleading to the court in any way that you all can help me. I mean, I'm willing to do anything you would say, but I am my mom's oldest son. She doesn't deserve to die alone, but I am innocent of this charge, but I would plead no contest to the court. Whatever, if somehow I can get probation, whatever stipulation you can put, whatever.
All
I
right.
would
So
have-
this is
oh.
not,
No, but I'm just
Time
stating
for
that I have,
equalization.
that's the problem with my mother. She got cancer. That's what he's saying, my mom.
Your Honor, if it pleases the court, he's under a great deal of stress because of this issue with his mom. He originally started with the PR bond, and then his bonding agency asked for a bond increase as a result of some issues associated with his bond. I think the state will probably go into more detail in that. But we're respectfully requesting that the court reconsider a PR bond for him. There is no violence involved in this particular case. And he would like to be able to provide some assistance to his mom. I'll pass it.
all right, you may proceed.
I don't really have any questions in this particular case.
All right. So, does he have any funds?
Judge, I'm appointed to his case. He is indigent. And I do not think that he has any funds that he can draw on, considering what has now happened to his mom, which was his sole source of income prior. I don't think that she's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property to rely upon in order to get anything other than the bond.
All right. So what I'm gonna do then, because you're saying there's no amount of bond he can make, he needs a PR bond. Is that correct?
Yes, sir.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
Your Honor, you were most kind, and I thank the court.
All right. So Norm, I want him evaluated for a PR bond, and then we'll place him back on the docket as soon as that completed. It should be done by next week, hopefully.
Not a
And
problem,
then-
Judge. I'm here every day.
All right. Thank you.
Thank you.
Morning. Thank you for addressing appropriately for court. So let me see. All right. So discovery, was that completed?
Yes, Your Honor.
All right. And today is the plea deadline date. So is this going to be a jury trial or have you all reached an agreement?
We have reached an agreement, Judge. There's one caveat that I should explain to the court.
Yes.
We're in agreement with all the terms. It's been a written plea agreement. We've
Mhm.
gone over it with Mr. Lunsford, and we do have an agreement. One of the things that the state wants to accomplish prior to the plea is restitution up front.
Mhm.
The state, and I don't want to speak for them, but my understanding is they need a little time not only to identify the specific recipients of the restitution by name, addresses, who the check should be made out to, and the amount. It's a substantial amount of money, and we are able to pay that before sentencing. So I would suggest perhaps 30 days to get those numbers done so that we can present the agreement to the court.
Let me make a suggestion. I would suggest that you all do the plea today, and I will set it in 30 days for sentencing. And then if for some reason and it will be set for a restitution hearing before the sentencing. And then if there is an objection to the restitution, if there's an issue with the restitution, we can handle it then.
I have no, part of the people argument is that it would be paid up front. So as long as the before sentence is imposed,
Yes.
yeah, then that'd be acceptable to the state.
All right.
Yes.
So then that way, once I'll take the plea today, the sentencing would not occur today. And I'm assuming there's no need for a PSI or TAP evaluation, or is there a need for that?
I think there is, Judge, because some of the terms and conditions, there are going to be things left up to the court's discretion. And
All right, well,
because
what I
of the-
can tell you is, sorry to interrupt, but what I can tell you is just to cut through things, a PSI is going to take 8 to 12 weeks. So we can enter the plea today, and then it'll be 8 to 12 weeks. That'll give everybody plenty of chances to get the restitution amount, and you all can confer off docket. Is that good for everyone?
That's fine with the state.
Yes.
All right, so if you guys will get the plea paperwork ready, I'll take the plea, and then we'll set it for a sentencing. What date would that be on, Ms. Ferguson? Well, no, it's going to be a PSI and TAP evaluation. Because that will give you more time with a PSI and TAP.
Yes.
So it'll be October 20th. And what I can tell you is PSI and TAP, those are two completely different things. So they're going to be two completely different dates for you to see probation. So make sure you meet all of those dates.
Yes, ma'am.
So October 20th, is that good for everyone?
Judge, I have a federal trial that day, but I don't think it's gonna go. If we're a couple of weeks out, that looks hard, then I'll talk.
Okay. All right. So we'll set it for October 20th, and I'll wait for you all to do the plea paperwork. Once you've completed that, just let them know and we'll take it out.
Thank you,
All
Judge.
right. Thank you. Who else? All right. Court is going on the record. Court is calling 2025 CR 1023 State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Sam Cogdill and Sam Log from the Schmucks.
And are you Mr. Lunsford?
Yes, sir.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, sir.
Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections? Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand you're charged with money laundering? Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with it, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him?
Aye.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand if you're not a United States citizen by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, sir.
According to the plea bargain agreement, the state is proceeding on count one. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Counsel, could you all check the box here? An
Yes, sir.
initial. Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was gonna recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yeah, ma'am, you just.
Sorry.
You said they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand? All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course in MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to count one, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, there's a stamp over the discovery.
I saw that too, Judge, a postage stamp.
Oh.
That made its way into the document. I wasn't sure what that was
So I'm not
about.
able to read that. If I lift it, it tears.
I can get another copy, Your Honor. It's going to take me a little while.
All right, no problem.
Okay.
So Mr. Lunsford, what's taking the court a while is that because this is submitted to me, I have to find that there's sufficient evidence to find you guilty. So I have to do my math to make sure this adds up. All right, all right. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record? All right. Once you sign the reset form and speak with probation, you'll be excused. All right. Thank you.
Thank you.
Thank you.
Your Honor.
Mark.
But the one time I did roll my R, everything just went haywire. So I don't think the universe was expecting it. All right. So today is plea deadline date.
Yes, Your Honor. So we were recently hired on this case,
Mhm.
just a couple days ago. We still need to go through the discovery, and Ms. Laraga has informed me that she has previous experience at the mental health court. We need to explore that also, if we could. So if we could get an extension on this plea deadline, we'd appreciate that.
All right, who's the prosecutor on this case? Shakira Laraga? Right, did you confer with the state?
Yes, just briefly, Your Honor, just to let them know that we've been was recently retained on the case. So we need to evaluate the discovery.
All right, so today is plea deadline date for them. She's previously been in a treatment court in the county court. And the last time we were here with this, there was supposed to be a consideration of the fact that she was in a treatment court.
We were just hired a couple days ago. I didn't realize that's been previously brought up to the state.
So, Ms. Ferguson, set this for the second week in September. And that will be your plea deadline date.
Thank you, Your Honor.
Thank you, Judge.
What date? All right, September 8th. Thank you for addressing appropriately for court. All right, just have a seat and your attorney will bring your reset form.
Thank you, Your Honor.
You too. Have a great day. All right, yes.
I believe we had a discovery setting. The very first initial setting was a discovery setting. At that setting, we got a offer from the state that was a time limit. We conveyed that offer. I believe we have received all discovery. I've tendered a discovery acknowledgement to the courts. And I believe the client wanted to address the court, but he formally rejects the offer.
All right, so do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that.
No, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you, that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here, we're here, whatever evidence is presented, and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. hypothetically and normally, this is what usually happens. The state has to prove that it happened in Bear County, because if it didn't happen in Bear County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
A reason why I don't want to take what the state is offering me because it's, I don't think prison is.
Here's the
I
thing.
would recommend.
Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They were like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state, because ethically, I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state, who's the state on this case with Jacob?
I confer with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
It's just the case that we discussed. Okay, yes, so thanks. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No,
Judge.
no.
That would be today only offer since
All
would
right,
be
And
changing.
that's how I feel in track. Like,
all right.
I feel like I got an ultimatum. I feel like if I hired another lawyer, I have a better chance to, get a drug program, because the whole reason why I'm not running from what I did. I
wouldn't seek further, but don't accept any, don't admit any guilt. Just please don't say something. Your Honor, we were here on a prior setting earlier this week. He had some time to think about this.
Mhm.
I know Jason is leaving.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box and then I'll bring you back up at 10:30. And you need to let the court know whether you're accepting, if you've reached an agreement or whether you're going to jury trial. Those are your options.
Okay.
All right, thank you.
Discovery wise, we're fine, Judge. My client wants to to replace me with different counsel.
Mhm.
He's not cooperative with me. He has suggestions which I disagree with. And he's got a pro se motion in his hand, wanting to replace me as counsel.
All right, so are you going to hire your own attorney?
I was seeing it up in from what he different from me.
No, this is your attorney. And so here's the thing. Here's the thing. You can either talk to your attorney or not talk to your attorney.
It's not that me not wanting to talk to my attorney. He's been given certain types of evidence and he's not willing to share with the DA messages,
things that have happened to my
And
wife.
you,
for
let me
10
ask you
years.
something. Here's the thing. Maybe if he is not sharing something with the prosecutor, maybe it may be because it's in your best interest that it not be shared. So I don't know anyone, this has to be the only profession where people get an attorney and they think that we have no knowledge, that all we're doing is talking. But there's a lot of knowledge behind that. And everybody thinks that they can be an attorney without having gone to law school. I have yet to meet anyone who goes to see a doctor, and if they're ill, they go to the doctor and then they get their second opinion or whatever, and then they say, you know what, doctor, I know better than you. So this is your attorney. If you want another attorney, you're more than welcome to have one, but you will have to hire that attorney. Do you understand?
No.
All right, so we're gonna set this for a plea deadline date. Norma, set this for a plea deadline date, the third week in September, please.
If I can speak freely on,
I don't know if your attorney wants you to speak freely, but I was willing to listen.
Judge.
there's a person that this happened to on this case has made a false police reports and everything else.
Mhm.
He's not willing to share any of this with the DA.
Big state, he's saying that somebody made a false police report on this.
Not to my knowledge, Your Honor.
January 25th. You haven't told him anything, right? You're refusing. to
All
show him
right,
anything.
so we're gonna come back on September 18th. I'll need an acknowledgement of discovery completed. All right, so we're gonna bring you back on September 18th. September 18th will be your plea deadline date. And then next date will be a jury trial date.
That'll work good.
All right, thank you.
Thank you.
Counsel, have you received all discovery? Did you review it with your client?
Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated with a child under 15. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she does.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering this plea, if you're not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the United States?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends, the state recommends community supervision. They're taking in consideration 2025 CC 011952, and there's to be restitution to Victor Flores. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, ignition interlock for half the term, 2-year license suspension, parenting classes, AA meetings, and UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, state moves to admit what has been marked as State's Exhibit 1 in all attachment.
No objection, Your
All
Honor.
right, state, you may be excused.
Good.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I mean, this is her first criminal offense. I mean, obviously, situation she is at right now that the court has her attention. I believe she's going to be a very good probationer and you're not going to hear from her again, Judge.
All right, so how often have you been drinking?
I haven't since then.
All right, so here's the thing, and I tell this to people all the time. When I was a defense attorney, I never had a client who said, my intention was to go out, get as intoxicated as I could, drive, hit someone. I've never heard anybody say that. But the problem is when you go out drinking, you lose control of your normal faculties, both mental and physical. And then you go out and you hit somebody. And you had a child in the vehicle that could have easily been a dead child. That could have easily been a child that was severely injured, because usually, and I haven't done the statistics on this, my professor would be upset with me for saying this. But normally what I see, the person who drinks and drive, they usually end up walking away. The passengers end up being injured. The person they hit ends up being injured. You just have the soccer mom or the grandfather who's just enjoying their life and somebody's drinking and they hit them. You're one of those people who cannot drink alcohol at all. And while you're on this probation, you're not allowed to drink alcohol at all.
Yes, ma'am.
So don't drink. You don't need to have alcohol to have a good time.
Yeah, and I've been sober since then. I haven't touched any beer, nothing, and I'm not trying to either, especially because of my kids and my granddaughter.
Okay. All right. This is what the court is going to do. The court is finding you guilty. Are you employed?
Yes, ma'am.
What do you do?
I work at O'Reilly's.
Auto parts.
Yeah.
Oh. Okay. Well, you know, but now that song is going to be in my head forever. Thank you a lot.
But mine too, Judge.
That song's been in my head, especially because I did the parade for work.
So do you sell parts and give people
Yes.
advice?
I'm a dispatcher. I sell parts, I pull parts, make sales, everything, basically.
All right. Court is going to sentence you 2 years in the state jail facility, suspended and probated for 4 years. There's a $2,000 fine. That will be probated. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be a TAP evaluation out of custody. Follow TAP recommendations, with the exception if they recommend inpatient treatment, we'll start with outpatient treatment. There's going to be 30 sober meetings in 30 days. 100 hours of community service restitution. I'm going to order the parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. Field visits 1 time per month for 3 months. Ignition interlock for half the term. A 2-year driver's license suspension. The victim impact panel live. DWI education course. And there's to be restitution, if any, to Victor Flores. Norma, I need a restitution hearing in 3 weeks, please. That's 3 weeks? Yes. No problem. I was like, are we already there?
Oh, I'm sorry.
All right, September 16th, the state is going to come in State on this case, September 16th, that will be our restitution hearing. Taking consideration 2025 CC 011952. Probation, is there anything else? All right, is there anything else you need from the court to be successful?
Just anything that what I could do to stay out of trouble, which I still have
I
been.
think they're doing a good
All right,
job.
just make sure you communicate with probation. That's a big start, okay?
Yes, ma'am.
If there's anything you need, just let us know. Let probation officer know. If you feel as though they're not addressing it, you can come back to court. Do you understand?
Yes, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and does she only have a warrant on this case? All right, so, and the court will recall the warrant. All right, thank you. All right, so, sir, here's my question for you. Are you on probation? So why do you think that if you're on probation, you get to make your own decisions without contacting probation beforehand?
No, ma'am. I've been in contact with my probation officer. I let her know that I was gonna be losing my apartment, that I had permission to travel to Fredericksburg.
Oh, and did she say you could move to Fredericksburg?
No, ma'am, I was starting to stay there in the weekends and I lost my job.
No. See, you're not internalizing what I'm saying.
Yes.
Did probation give you permission to move to Fredericksburg?
Eventually, yes.
But no, before the move.
Well, I was staying there. I was spending the night there visiting, but I was not staying there. I still had
Did
an apartment
probation give you permission?
to travel. Yes, ma'am.
No, my question is, did they give you permission to move to Fredericksburg?
I
That's
wasn't-
either yes or no.
Not live there, no, but I was visiting.
All right, so again, you are on probation. Why do you think you can just do what you want to do? I'm sorry,
I don't think that, ma'am. I knew it.
but your actions are saying something different. You are not allowed to move to different places without probation's prior permission. When you're on probation, that is a contract. It does you no good to ask for forgiveness rather than permission. While you're on probation, you have to ask for permission.
Right.
Because when you're coming with probation and you're asking for forgiveness, you know what that results in? That results in me getting notice that you're asking for forgiveness, which asking for forgiveness is a violation of your probation. So you need to ask for permission prior to making moves because you're under contract. You understand? Probation. Are there any other concerns? Has anybody received any type of documentation that he is actually now living in Fredericksburg? And then we have on this supplemental report that they made contact with you for 4 field visits. And they attempted to complete the field visits, but I'm assuming you were not there.
I mean, my work schedule had me away from home.
Did you tell them that?
Yes, ma'am. I had text messages where I was communicating with the visitation officer. And I let him know the situation in my work schedule. And I also let my probation officer know.
Here's the thing. I don't know why they would put in their report they're attempting to make field visits if you made contact with them and said, I'm not going to be there.
They called me and they sent me text messages. And
Call you and said, where are you, right?
well, they asked me if I was home and I said, no, that was at work.
So that's not, that, again, that's, you're not understanding what permission is. Yeah.
Were signed on August 25th, addressing his transfer to reside.
This copy of
You cannot, I repeat, you cannot ask for forgiveness anymore. Do you understand? You're going to have to ask for permission. The next time you ask for forgiveness, what's going to end up happening is I'm going to receive notice And in that notice, they're gonna ask, should we do a compliance hearing? What should we do? And if it's the same thing where you're not following through and you're just living your life, and I know people just want to live their life, but when you're on probation, you just can't live your life like everyone else because you're on probation, you're under contract. You understand? So no more asking for forgiveness. You need to ask for permission. Now, is there anything else you need from the court?
No, not this time.
All right. So probation, you sent me this supplemental report, and they were asking for Sabbath is listed on here. So your conditions include intensive outpatient treatment. So have you been doing that?
My probation officer is waiting to get back to me, and I told her whenever we're available to start that I'm ready to start that. I've completed the 120 days. I started to look into parenting classes online and other resources online, so I should start taking
All
care
right,
of that.
so you need to start
And
intensive outpatient treatment ASAP. Anything else?
no, I was gonna finish by saying that I spoke with the probation officer. She said she was gonna get back to me as soon as she heard back from outpatient or whatever office or
They're here.
people were gonna, set me up for that so that I can start those classes on.
So you're gonna start it, okay?
Yes, ma'am.
Anything else, probation?
No.
All right, thank you.
Thank you very much. for your
You're
time.
welcome.
You have a great day, ma'am.
Thank you, you too. Thank you for dressing appropriately for court.
Yes, ma'am.
Good morning. How are you doing today?
I'm hanging in there.
Oh, you got to do better than just hanging in there. Life should be about more, right?
Should be.
All right, yes, counsel.
Judge, my understanding is we're set for a probation status. I talked to probation this morning. It looks like Mr. Kitchen's probation was trying to county. One of the conditions was that he enroll in Veterans Court.
Mhm.
And it looks like he hasn't enrolled in Veterans Court. When I talked to him about it, and I think in conversation with probation, it looks like Mr. Ketchum has let me know that he doesn't qualify, or he's telling probation that he doesn't have any substance abuse problems. And so he doesn't want to give up his spot to a veteran who does need substance abuse program treatment. And I believe that's why we're here this morning, Judge.
All right, so here's the thing. We were here. I remember your case. You're supposed to be going to Veterans Treatment Court there.
But they didn't accept me into the program. I don't have a drug or alcohol problem. I've been very vehement with my former attorney who I fired due to malpractice.
No, so here's the thing. You're supposed to be in Veterans Treatment Court. That's where you're supposed to be. And Veterans Treatment Court is not necessarily 100% about drug addiction. Sometimes it's about mental health issues and other things, but that's where you're supposed to be. And I remember you, and we had a long conversation concerning this. Could I see his file, please? Yes. And we were here, and I said he would not be allowed to transfer to Austin unless he was monitored in court. And his attorney was here, and we went over these long hearings about his being transferred so there could be a smooth transition to Veterans Treatment Court in Austin.
Understand, Your Honor. And I spoke to the individuals over there and they denied my entrance into the
Oh,
program
I'm sure they will deny it if you say I don't have any problems.
because I don't have any drug or alcohol.
All right, so
problems.
here's the thing. You're not going to be living in Austin.
Understand.
So he's not gonna be living in Austin because those were the rules for in order for him to reside in Austin. And you come before me and then you go somewhere else. I don't have a drug problem. I don't have a mental health issue.
I never stated I don't have a
But-
mental health issue. I've been seeing the VA regularly.
Yeah. So he's supposed to be in the Veterans Treatment Court in Austin Council.
Okay.
That's where he's supposed to be. And if he's not gonna be in that program then he's gonna have to be here.
Okay.
For supervision. So it's up to him. That's the last choice he will have.
So the body's on the plan for the conclusion. I would put all the and all the units that I've done everything I've seen.
One of the conditions.
Nor 40 over the control of them. Program on the denying program. I can only be honest with them, and I've been honest with them. And they should not with program.
To go back to. So then how much longer do I have to, this program, this program? I'm trying to get on with my life. I've lost everything. I've lost my favorite animal. I've lost my home. I've lost my possessions. I have no family left. I'm doing the best I can under circumstances that are way beyond my control. Being-
All right, so I'll let you all discuss that. All right, thank you. All right, counsel, yes.
Judge, after confirming with my client, he's indicated to me that he's gonna choose to remain in San Antonio and get monitored by probation. He's elected not to go back to Austin and participate in the Veterans Court program.
All right, state, this is Tyler Richard Paul Ketchum. And I don't believe we were here for a motion to revoke. It was just compliance. Is that correct?
Yes.
All right, so his conditions are going to be altered and amended to include a return to Bear County. And he will be supervised here in Bear County. And if you all can do an updated TAP evaluation. And also see if Veterans Treatment Court here will accept him.
Okay.
All right, is there anything else, counsel?
Not from defense counsel, Your Honor.
All right, thank you.
Thank you, Judge.
Thank you. All right. So he has a motion to revoke.
Yes, Judge.
Yes,
But we're here to resolve that. Judge.
okay. All right, the court is calling 2022 CR 6213 State versus Justin James Gonzalez. Can I have parties announced for the record, please?
Rick Pena for the state of Texas.
Orlando Costin, Lunsford defense.
And are you Mr. Justin James Gonzalez?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Justin James Gonzalez who was placed on deferred adjudication in 2022 CR 6213 for the offense of aggravated assault with a deadly weapon on September 20th, 2022 for a period of 7 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 2. On or about the 16th day of July, 2024 in Bear County, Texas, the defendant, Justin James Gonzalez, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
You plead to that, true or not true?
True.
State will waive the remaining violations, Your Honor.
Any objections to the waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor, and that is to deny the motion and alter and amend conditions to add safe P followed by safe P aftercare.
And that is correct, Judge. We were here about 10 days ago. Mr. Gonzalez, at that time, we were going to go forward with this motion. He wanted to take that 10 days to allow me some more time to prepare because I had just been assigned that day. I met with him at the jail and we discussed this case. My belief was that these violations, there were some issues, I think, improving that, he did participate in one of the classes, and we needed to get, I guess, payment to them to provide the certification of completion of one of those programs. He was in the process of enrolling in parenting class. He told me that, he had done 90 days cognitive with ISF, but he had not done a substance abuse track. And that he actually wanted treatment. And so it kind of took me aback because I didn't believe that's where we were at when I first met with him. He said, no, I want to be treated. I want to get treatment. He was very motivated for treatment. He was asking for 90 days substance abuse track. If not SATA, speaking with the state agreed that if they were going to make a recommendation, that it would be for safe P. Even knowing that that's a longer program, Mr. Gonzalez said, I want treatment. And so I believe he's motivated for treatment and that wants to help get past any of these substance abuse issues that he has.
All right. So I'm going to give you a choice. You know yourself better than I do, better than probation does, better than your attorney does, right? but you're gonna have to be 100% honest with yourself. You've been before me previously on a motion to revoke. So these are all your only choices. There's no other option. I can deny the motion. I'll alter amend conditions to have him go to safety. I don't believe he's going to be accepted in felony drug court based upon his tattoos and their meaning. Or I can revoke you, and I'll revoke you and I'll sentence you to 7 years. Those are your two choices.
Safety.
All right. So the court would deny the motion, alter amend conditions to include SafeP and the aftercare program.
Yes, sir.
And upon release from SafeP and the aftercare program, he's going to do 90 sober meetings in 90 days.
Yes, sir.
All right. Is there anything else that you need from the court to be successful?
No, Your Honor.
All right. Probation, is there anything else?
far as the pending case out of Comal County, you know what's gonna happen?
I don't. It's a driving while license and all that.
Just because he'll be in limbo
Well, yes.
until that case is resolved, so we can do the referrals, but.
I don't believe it's been filed.
Well, if somebody could reach out to Comal County,
Yes, sir.
I'm sure a driving while license suspended, maybe. They will take care of that.
Okay.
All right, so what we'll do is, Norma, recall this for the end of September, just to make sure that that case has been taken care of. If it hasn't, we'll need to do something, because otherwise he'll just be sitting at the jail.
Thanks.
All right, so we'll be back on September 29th. However, if that Comal case has been taken care of,
He's on bond, he says, on that particular case.
but still it's pending.
Yeah. okay.
So if by September 29th that case has been taken care of, we won't have your hearing in this court. You'll just be waiting for a bed at safety. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
You're welcome. State versus Eduardo Escalera. Could I have parties announced?
George Fania for the state of Texas.
Budred Nair, Mr. Escalera.
And are you Mr. Escalera?
Yes, sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it? Are you the same Eduardo Escalera who was placed on deferred adjudication in 2020 CR 0291 for the offense of violation bond and protective order two or more times within a 12-month period on August 2nd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation condition number 20. On or about the 11th day of July, 2025 in Webb County, Texas, the defendant Eduardo Xavier Escalera did then and there fail to register for, attend a parenting program with the approved agency in violation condition number 20.
How do you plead to that? True or not true?
True.
The state will waive the remaining violations, Your Honor.
That's what I'm defending.
Any objection to the waivers? Did you understand by pleading true to violation of condition number 20, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
Yes, ma'am.
Court will find violation of condition number 22. Is there proposed agreement?
There is, Your Honor, and that is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 2 years prison.
I'm sorry, how many?
2.
That's the agreement, Your Honor.
Are you asking the court to follow that agreement?
Yes.
All right, has he done anything on probation? Has he completed anything?
I did my community.
You want to raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hands.
I finished my community hours at SATF. I attended SATF. I completed SATF. I also, I enrolled to my VIP classes, but they made me start over because I missed, I think, 2 weeks. So they made me start over again.
So why didn't you complete your parenting classes?
Well, it's because in Laredo, that your kids had to be a certain age to attend it, but I was gonna start with the same professor there, but I had to finish the VIP classes first.
problem is primarily drug abuse, Judge. Frequently, he was extended a year ago,
Mhm.
for a year. Since then, it is concerned, most of the violations have been either a failure to show a positive or diluted in drug tests.
I did attend an outpatient program that I emailed a certificate to my probation officer in Laredo, and I think she emailed it over here. It was called SCAN. And my counselor there was Carla, and I did it for 6 months with drug testing and everything.
Mhm. All right, probation. What are you requesting?
Probation's recommendation is to extend him for 2 years. For to attend the safety program.
All right,
That's a fact, but it is.
here are your choices. These are only two choices you have.
If I may, Your Honor, before you,
Yes.
I just want the court to be aware, as far as what probation said, his probation did expire at the beginning of this month.
Okay.
So,
All right, so here are your two choices. These are the only choices you have. I can revoke you. I'll sentence you to 3 years in the prison. You get credit for any successful completion of inpatient treatment because legally I'm required to do that. Or I can revoke you, find you guilty, and grant you probation, but you'll be going to safety.
So it's the 3 years, not 2.
Yes.
And how long is safety?
I'm sorry?
How long is that program?
Well, you have an aftercare program that I believe is 3 to 6 months, and the actual program in custody is 9 months.
Okay, I'll do that.
I'm sorry?
I'll do the safety, because, well, I thought I was gonna do the 2 years in TDC.
You want to discuss it with your client?
Let me discuss it with him, I may, Judge.
All right, so I'm going to let your attorney discuss that with you. Counsel, you can discuss it with him and you can appear by Zoom if you can't be back this afternoon. All right, so the
Thank
court
you.
is going to, you're welcome. So the court is calling 2025 CR 007563, State versus Ronald Lamar Allen. Can I have parties announced?
Lauren Smith, state.
Charles W. Booker for the accused. Ronald Allen?
All right. Counsel, you received all discovery?
Yes, I did, Judge.
And did you review that with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Allen, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, I did.
Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes, I did.
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Allen, did you review the court admonishments and waivers with your attorney?
I did.
Did you understand it and sign it in all the appropriate places?
I did. I did.
All right, you're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
I do.
Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, no.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
And counsel, I believe we had any pretrial motions?
We did have some pre-trial motions previously on this case, and they've been disposed of.
All right. Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state tenders, what has been marked States Exhibit 1 and all attachments.
All right, did you review any objections?
I have no objections to those pieces, Judge.
Mr. Allen, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right, any objections to the court reviewing the? Okay. All right, yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr. Allen.
I'm just saying, based the judge's notes that you gave me, they have these people listed underneath protective order.
Judge, I don't think that's accurate at all. I think that's being misread right now because
I mean, that's the only way I can read it because, and the reason why I'm saying that's the only way I can read it is because it lists Medley, it says protective order, and then indented right underneath, it says M. Medley, which is the state has outside the agreement. They're asking for a no contact order with that person, with Charles Ireland. And then they have someone by the name of Gallegos and Ramirez.
right, and
And then right after it says that it has protective order, then right after it mentions those three names, then again, it says 2-year protective order granted as to, I believe that's the mother. of
that's the
child.
mother's name. Yes, Mrs.
So-
Allen. Yes. But there is no protective order granted in that order regarding Mark Medley, regarding any of those people. The only one that has a protective order granted against is the mother of the child that we're talking about here. Ms. Gallegos is here and she hasn't asked for a protective order, and we know that the amicus doesn't have a protective order either.
Okay, so this is what I'm going to do. I've taken your plea. And if somebody can tender to the court, whatever the orders are on the civil side, I'll review those because those judges' notes that were handed to me appear that there's a no contact order. And I think you want to have those,
Right, exactly.
know for sure whether it is or not, because otherwise you may be violating orders over there.
Absolutely, absolutely, black and white.
So what we're gonna do is, I've taken your plea. If you all are waiving PSI, I won't set it for a PSI. We'll just come back. When I'm back, I'm gonna be gone the first week of September because I have to go to a judicial conference, have to keep up my educational courses. And then the second week, I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September. And that'll give everybody a chance and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Medley listed as a no contact person too.
Well, and absolutely, and we understand that Mr. Medley called and asked for that kind of to be added to this order. That's my understanding from my discussions and my review of the state's file. But I think the reason you see this line that says protective order plus merits is because that is what the topic of the entire and what you're seeing here is actually the litigants that are or the attorneys representing each of these litigants.
The best way to discover what that means is
Yes.
the judge.
I just have one request. We have services from my father September 5th. And I'm on the.
Go to the
DPS.
services.
Yes, thank you.
Yes.
Absolutely.
But here's the thing about going to those services. And state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order and I will do the style and you all need to write down your agreement.
Okay.
All right?
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson?
Yeah.
When can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side.
Yes.
So that this could a little bit be in harmony.
Absolutely, I agree.
I can do the 16th.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case
All right.
in order to make their orders. And that's one of the reasons Ms. Gallegos is here.
All right, Ms. Gallegos, if we can go off the record, Ms. Gallegos, if you'll come up. All right. Hello, how are you doing?
Yeah. Good, how are you?
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes, the way it's written, it appears that you're a part of the protective order. Medley is a part of the protective order. So if the court can get clarification from the judge on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly appreciated.
Okay, we have a conference call next week, and then we will be looking to get it entered We are hoping to obviously do it as soon as possible, and we will try to meet your deadline of the 16th. And I'll let the other attorneys know. If not, do we need to send an email to Ms. Ferguson?
No, I mean,
Okay.
so I'll just need that information before the 16th. So if you all can get the judge to, if you all want to, you can have the judge email me and
Okay.
say, this is who's a part of the protective order. Or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me this is the part of protective order, because the way the judge's notes are written,
Mhm.
it's so.
Okay.
Oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's the petitioner. Margaret Gallegos, me, I represented the respondent, and then Anna Ramirez was the amicus.
Yeah, no,
And then it goes
But
down.
the reason why I say that is
Mhm.
because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that printout one more time?
Oh, I don't-
So that's why I
Okay.
need clarification, because the way that's written in the judge's notes, as you can see, it has a title protective order. Then it has a list of 3 people. Then underneath that list, then it comes back with a 2-year protective order. So it seems as though those are the people that he has a protective order against. So I would prefer that he know, I would prefer that I know, and probation knows.
So on here, it says 2-year protective order granted as to Mrs. Al.
But above it, it says protective order.
Okay.
So if you all will fill in the dates for him, please. And what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right, and if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right, so we'll come back on September 16th, and at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation.
I would.
All right, so thank you.
Thank you, Judge.
All right,
Thank you.
Thank you.
Thank you so much. I appreciate it.
You, and thank you for dressing appropriately for.
Absolutely, absolutely.
All right, and you're not excused until you sign the reset form, okay?
Absolutely.
Thank you, Judge.
All right, thank you. Yes. Probation, there's no PSI or TAP on that. He's, all right, the court is calling 2025 CR 0018230 State versus 1 Cruz. Can I have parties announced?
Ashley Jones for the state.
Christine Brown on behalf of One Cruz.
And are you Mr. Cruz?
Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery and there are no applications, correct?
There are none.
Mr. Cruz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We waive the reading of the indictment. We did want to note that the state is moving to amend it, and we waive that 10 days notice attached to that amendment.
All right.
Yes, Your Honor. The state is moving to amend the indictment to reflect the correct spelling of the pseudonym name as well as the word pseudonym.
Mhm.
So we're just changing that. And then additionally, we are proceeding only on count 3, and we will waive all other counts. Further, we are waiving the habitual enhancement allegation.